Okay. Good morning, everyone. This is Constitutional Attorney Catherine Henry. I do not want to have to try to do this 3 separate times like I did on Friday. So what I am doing is I'm going live on one camera from our YouTube channel and one camera from my personal profile, and then another one from our Restore Freedom with Catherine Henry page. Want to make sure we can get all this information in front of people as quickly as possible. Because I'm doing all three, I'm not going to be monitoring the comments during this. This is it's not a Q&A kind of video. That was done for hours on Friday. This is one I want you to be able to share. So this is going to be as short and sweet as I can make it while still answering the big concerns and questions that are looming about what happened in the Supreme Court on Friday. So with that being said, the main recap from Friday is that the Supreme Court said that the governor did not, and I'm reading from the court's syllabus. This summary essentially is a 4-page thing that comes from the court itself. It's not part of the actual decision. It is, but it is the official syllabus that's coming from the Michigan Supreme Court. It's nothing I wrote. In here, it says that the court unanimously held that the governor did not have authority after April 30th, 2020 to issue or renew any executive orders related to the COVID-19 pandemic under the Emergency Management Act. So what does that mean? 7 out of 7 justices, regardless of political party, said, hello, she does not have the right under the Emergency Management Act, the 1976 law, to continue issuing these executive orders, okay? Then the second piece to this is in a 4-3 majority, which is still the same. It's still as binding upon her as anything else would be. The court said that the governor did not possess the authority to exercise emergency powers under the 1945 EPGA because the act itself unlawfully delegates legislative power to the executive branch in violation of the Michigan Constitution. So what does that mean? In other words, if you look on page 3 of this syllabus or summary, it says that the EPGA, the 1945 law, is unconstitutional in its entirety. So that means, okay, A, she has no authority under the 1976 law, they said, after April 30th. So state law does not allow her to go beyond April 30th. And then the Constitution does not allow her to use the 1945 law. So in order to do these executive orders, these COVID-19 executive orders, she was relying on doing things under one of those 2 statutes. She cannot do them anymore at all. Everything she's done after April 30th, the Supreme Court of Michigan has said is over. It's done. She has no more emergency powers after April 30th. Of course, I argued in the Supreme Court that she didn't have that ability to do so from day one because even the 1976 Emergency Management Act violates our constitutionally protected God-given liberties. But nonetheless, at least what they are saying is after April 30th, there are no executive orders in effect other than the ones that are the traditional, simple executive order branch restructuring, okay? Things that have nothing to do with COVID-19, things that do not directly impact we the people in any way. Last I checked, there were 11 of the near 200 orders related to those kinds of things. But so I'm not talking about those executive orders. I'm talking about the 94% of all the other orders, anything to do with COVID-19, she no longer has the authority to do after April 30th, which is why I said that on April 30th on the steps of the Capitol, and why I made a Facebook and Twitter post about it that evening. So to recap, 7-0, 7 justices said the 1976 law is a no-go for her anymore. And we also had the court come out and say that the 1945 EPGA itself is unconstitutional. She can never use it. Here's the benefit, and here's another way of looking at it, I guess I'll say. The 1976 law, the court said she can no longer use it for COVID-19, right? So if we have another huge flood like we saw in the Midland County area, that's permissible because that was a totally different type of emergency or situation is what they're saying. But she is stopped from using COVID-19 as a reason to exercise powers under the first question they answered. Under the second question they answered, no governor in Michigan can ever use the 1945 law. No governor can ever use it ever again, period. Not her, not a Republican, not an independent. No governor from now on, it's clear, can ever use that Emergency Powers of Governor Act. So with that being said, let's see, what are some of the other, so the governor has said she has 21 days, right? That we have to follow her unconstitutional and illegal orders for another 21 days. That's not a thing. The only two things about 21 days that she could be remotely referring to or that she is trying to refer to in her press releases and everything come from court rule. Okay, so if you go, you can go to the Supreme Court's website. The public has full access to the court rules, and you look up Michigan Court Rule, or MCR 7.311, subdivision F and subdivision G. Subdivision F is if she's asking for a rehearing on it. The interesting thing here, though, is that this is not a typical case. This is not something where a court case was filed in, say, the Court of Claims against her, and then the losing party appealed it to the Michigan Court of Appeals, and then they eventually appealed it to the Michigan Supreme Court, and then the losing party is asking for another hearing. This situation it came out of a case where 3 doctors' offices and 1 patient sued the governor, the attorney general, and the Michigan director of the Department of Health and Human Services in federal district court, so trial court level in federal court. That district court judge said, you know what, if I can resolve this case, if the plaintiffs can win based on state law or state constitutional claims, then we need to have that addressed first. So because these issues had not been addressed yet by our state's highest court, the federal district court certified 2 questions down to the Michigan Supreme Court. And the Michigan Supreme Court is the highest court that she could possibly go to on state law violations or whether our state statutes violate the state constitution. So let me make it clear. Let's say the question was in general whether the EPGA or the executive orders violate our U.S. Constitution. Our state Supreme Court is not the highest court in the land for that. The United States Supreme Court could be the next court after that if the losing party decided to file an appeal. However, that is not the questions that were posed to the Michigan Supreme Court. Literally, the Michigan Supreme Court was asked by the federal court to give them the final answer on whether the governor violated state law. Federal courts don't have jurisdiction over that. They're not going to touch that issue. So the state Supreme Court is the highest court that can answer whether our governor, with her acts in the state of Michigan, violated state law. Then you have the issue, the question 2 was asking if our state law violates our state constitution. The federal courts have no jurisdiction over that. This is not an issue of U.S. Constitution. It was boiled down just to whether our state law, the 1945 law, violated the state constitution. And the Supreme Court of Michigan said, yes, the state law violates the state constitution. So they simply gave the answers of those 2 questions back to the federal district court. So the federal district court can use those answers to then determine how the case itself gets settled. How does it get resolved? So we've had the question about whether the governor can appeal. The governor cannot appeal this to any higher court. The Michigan Supreme Court is the highest court that can handle issues of whether a state government actor, such as the governor, violates state law by doing something, and whether the state law itself violates state constitution. So there is no appeal to any other court for her. So that leaves the only two things about whether this court can do a rehearing, hold a whole other hearing on this, or whether they are going to, if she wants to file a motion for reconsideration. So what's important to kind of note is that the legislature, when the Supreme Court of Michigan decided not to take the legislature's case against the governor before it stopped at the Court of Appeals, the legislature, through their attorney, Michael Williams, argued and filed a motion that was asking for reconsideration, was asking for the Supreme Court of Michigan to reconsider their decision and, in fact, allow them to have their case jumped over that Court of Appeals stage of things and be heard in the Michigan Supreme Court. And the Michigan Supreme Court was actually pretty quick in coming out to say, nope, we're not going to reconsider that. We're just going to let things go the way that they've been going. They've been very deliberate about when they're going to hold things off and make things go slower, if you will, versus, in areas where they've sped things up. They had an expedited or sped up briefing schedule for this issue, this case to be heard in the first place. And then when we were arguing on September 9th, those of us attorneys that were participating in the case to that point were alerted that the court wanted additional questions answered to help them sort this issue out. And those briefs were due 1 week later. So from one Wednesday on the 9th to the next Wednesday on the 16th. In the land of, maybe writing a newspaper article or, doing a paper for college or, some sort of report that you might do at work. Yeah, that might not seem like a very sped up period of time. That might seem like a very slow window there. But in the legal world, and as one of the attorneys that wrote one of these briefs in that week, it was exhausting and it was a lot of work. I don't know how much work the other attorneys put into their briefs, but I could tell you I thoroughly researched everything that I put into mine, and it takes a lot of work to do that and to put it to the proper format. So, and then of course I had technological issues on that last day, trying to get it uploaded. So that was special. But in any event, it was a very expedited briefing schedule to have those additional questions answered. And what I've been telling people, if you've been following me on Facebook or on YouTube or, just through my website in some way or seeing me go to the various events or rallies or doing the speeches across the state, then you would have heard me say that when everyone kept answering, well, when is the Supreme Court going to give us an answer? I've been telling people that they didn't have to answer this question in the first place. Legally, they did not have to. And if they did, they could choose to drag it out. And that's something that Justice Markman was actually concerned about and wrote in one of his dissenting opinions along the way here. However, what I've been telling people is based on everything that I've been seeing, I was very confident that the court was going to issue a decision by late September, early October. So basically, roughly like 2-3 weeks after the hearing. And guess what? They did. So I'm telling you that is it is fast in the grand scheme of things. Now, why do I hammer on that point? Well, because if the governor is going to try to ask for another hearing or, file a motion for reconsideration, telling them you've got this all wrong, you don't know what you're doing, I think the court was very meticulous about which parts of this they slowed down and allowed extensive oral argument and briefing, and which parts they sped up. So they were still providing answers. Now, I disagree that they should have slowed it down at all. I think that they should have sped it up right from the get-go, and we should have had this case heard in the beginning of June for sure at the state Supreme Court. But regardless, I think that they've been very deliberate about the speed at which they're doing this. And I feel very strongly that they are not going to entertain a motion to have a whole nother hearing on this. There were how many of us attorneys? It was the plaintiff's attorney, then myself, then the legislature's attorney got to participate, and then the governor and the director of Department of Health and Human Services had their own attorney. The Attorney General's office then had an attorney representing, And then the House Democratic Caucus, I believe, 6 attorneys that were able to argue that day. And the scheduling for such a thing can be obviously quite a nightmare, and et cetera. So I truly believe, and if you watch that video that day at the Supreme Court, they argued, or excuse me, they had arguments happening. We as attorneys were on by 9 a.m. and we didn't log off until somewhere between 1:15 and 1:30 that day. That's quite a bit of time to be hashing out all of these issues, especially when the main issue was actually very minute. It was very pinpointed. So with that being said, I do not believe a motion for rehearing is even reasonable at this point. I would like to think that the governor is not even going to waste our tax dollars and resources on even filing such a ridiculous thing. Motion for reconsideration, if she strongly believes that they got it all wrong, if anything, she can file a motion for reconsideration. Now, why am I telling you all this legal crap? Here's the reason. In this court rule, it talks about the 21 days that basically, in this part of the court rule, she has to file her motion for reconsideration within 21 days. Sure, that part's in there. But MCR 7.311G, on a motion for reconsideration, it says this at the very end of this little paragraph here. It says this sentence: the filing of a motion for reconsideration does not stay the effect of the order addressed in the motion. What that means is the Supreme Court's order that they came out with, I think it's not just done as an opinion, I believe it's an order, but regardless, in this opinion, there is no stay, there is no pause button, there is no legal authority whatsoever for the governor to think that she has this 21 days that everybody has to wait and follow these clearly unconstitutional executive orders. Not at all. So to the extent that the governor thinks she's either going to appeal to some other court, or that she has the right with Michigan court rules to force everybody to wait 21 days after our court finally has declared, in fact, these are unconstitutional and illegal, period. No, there's no legal authority for that whatsoever. So what does that mean? I was asked on a TV show, Fox 2 over in the Detroit area today, can we burn our masks today? Or what does this mean about the decision? Yes, you can burn your mask. You can do whatever you want with it. I mean, don't throw it on the street, because we've seen a lot of people doing that. I'm sure it's the same people trying to force us to wear the masks in the first place, littering theirs all over the place. But you do not have any legal obligation whatsoever to wear a mask. So because she had no right to declare a state of emergency or renew a state of emergency after April 30th, that was very clearly stated by the Michigan Supreme Court, then under that 1976 law, and the 1945 law is completely and entirely unconstitutional and can never be used again. Every single order that she has been issuing since then, based upon that state of emergency, they're all gone. They evaporated. They are literally void. And in Marbury versus Madison, in our U.S. Supreme Court, they told us, what was it, 1856 or something of that nature, that when you have an unconstitutional act by the government, it's not a law, it's not enforceable, it's as though it never even existed in the first place. So every single executive order that sets aside Freedom of Information Act, the Open Meetings Act, allowing state or local governments to be closed to the public in any way, shape, or form, closing off people from their families in nursing homes or juvenile care facilities, requiring people to wear masks when they're in public, requiring people to social distance, requiring or prohibiting people from exercising their rights to gather, to peaceably assemble, to petition their government for a redress of grievances, to worship as they so choose. All of those rights are still intact, and none of these executive orders are there. None of them. Every single one of those orders I mentioned and all the rest of them are gone. It's as though they never even existed. I hope that's as clear as it needs to be for you. I honestly don't know how else to say it. If you would like to wear a mask because you believe it's going to save you or help you, or perhaps you're immunocompromised, you have the freedom to do that. And I hope people are not going to give you a hard time about it, because they don't know what's in your life or in your situation. But if you do not want to wear a mask, or perhaps you are medically unable to wear a mask, don't worry about wearing one anymore. You do not have to. And yes, I know there's been questions about, well, or statements that, but private businesses can do whatever they want. They can tell you no shirt, no shoes, no service, no mask. I even saw a sign on a door that said that. They cannot do that. First of all, most of these, a vast majority of these businesses are doing this because of this executive order. When you are enforcing things upon the people, the customers, the clients that come into your doors as a business, because the government has told you so, because the government has said you must do this, well, then you are acting as an arm of the state. Then you are bound by all of the restrictions that apply to government because you're doing the government's dirty work. So of course you can't hide behind the whole I'm a private business thing. Now, let's say it's one of these few businesses that has tried to go with well, it's our company policy, right? Menards, for example. Does Menards have the right to tell a person in a wheelchair they're not allowed to come in their store because, there might be all kinds of cooties and germs and things on the wheels of their wheelchair? Can Menards say to somebody, I don't like that your shirt says Donald Trump 2020 for president, keep America great, so you can't come into my store? Does the store have the right to do that? If you think the answer is yes to any of that, then you need to move to another country because that is not acceptable in the United States of America. So just to be exceedingly clear, God gave us our rights. And I don't care if you believe in God. That's not my problem. That's your problem. You'll have to answer that for someday. That's not a discussion here. What is important is that our state and federal constitutions and our Declaration of Independence, all three of them make it exceedingly clear that we get our rights from God, and we are preserving those rights in our state and federal constitutions. In fact, the only reason why we create government in the first place, as talked about in the Declaration of Independence and our state constitution and our United States Constitution, is to secure the blessings of freedom and liberty that God has given to us. So God gave us a whole bunch of freedom, and governments are instituted among men to secure those freedoms. That is the whole point of government. Government is not there just to keep us safe and protected and be our mommies. I have a mommy. Her name is Kim. Her name is not Gretchen. So, and by the way, I'm 37, so my mommy doesn't get to tell me what to do anymore. We are adults, we are human beings, and we are given freedom by God. And government cannot act, literally cannot do anything unless they have been given that specific authority to do so in either our state or federal constitutions. If those constitutions do not give the government the right to act, they cannot do so. Now, we as people, everyone kind of takes the notion that, well, and this is state legislators, other attorneys, business owners, the average Joe, everyone in every scenario has asked me over the last several months, well, Catherine, where does it say in the state laws or in our constitution that I have the right to not wear a mask? Can you please tell me that so I could share it with people? First of all, we don't have to prove that we have the right to do anything. We are setting up our government to control the government to protect our rights, not to control us and protect the government's right to control us. No, we don't have to prove that we have the right to do something. God gave us those rights. Now, to be very clear, let's just look at the first 10 amendments, the first 14 amendments of the United States Constitution. Most of those are getting at the specific liberties that we as the people retain, even though we have instituted this government, right? And have this society. In fact, our rights that are being secured are those that we hold as individuals, not as a collective. So at any rate, despite all those individually enumerated rights, right? The right to bear arms, the right to be free from unreasonable searches and seizures, right? So we have the Second Amendment and the Fourth Amendment, the right to due process and the Fifth and 14th Amendments. We have the right to free speech and free press and freedom of religion, the freedom to hold our governments accountable, and in the First Amendment of our United States Constitution. We have all kinds of rights, but let's not forget the right under the Ninth Amendment of our United States Constitution. That might be the most important of all. Why? Because it says God gave us a whole bunch of rights. We don't have to list them all. If we didn't list it, it doesn't mean it doesn't exist. And it doesn't mean that the government isn't supposed to be protecting it. The government still has an obligation to protect rights that we have been given by God, even if we don't enumerate those in the Constitution. Now, you may not like that clause. I didn't write it. It's in there. We're bound by it. In fact, if you have taken an oath of office anywhere in the executive, legislative, or judicial branches, Article 6 of our U.S. Constitution requires you to uphold that part of the Constitution, whether you like it or not. Also, our state constitution does the same thing. Our state constitution, you look at Article 1 of the entire Article 1 of our state constitution here in Michigan is the Declaration of Rights. And those rights, there's quite a few. I want to say we have 27 in our state constitution that are enumerated. Guess what? We also have Article 1, Section 23 that says the same thing, that we have unenumerated rights. We have rights that we did not take the time to write out, like the right to go in public without being restricted on airflow by a mask. We have that right. It's just found in Article 1, Section 23, the unenumerated rights. And so if you serve in state or local government, whether it's on a school board or whether you're part of the public health department, whatever, it doesn't matter. If you serve in state or local government here in Michigan, you have zero right to trample on the freedoms that are guaranteed to us in that entire Article 1 of our state constitution. And in fact, in order to hold that position, you are required to have the same oath of office to uphold the U.S. and Michigan constitutions. If you work for the government in any way, shape, or form, you took an oath to uphold the U.S. and Michigan constitutions, whether you like them or not, period. So with that being said, I want to make sure I covered everything, the big questions here. Could this decision from our state Supreme Court have any effect on any other state in the country? The case is venued in federal district court, remember. But no, the questions here today do not have any direct bearing on any other case in other states. It can be influential, it can be persuasive, but it doesn't directly impact the other courts. And people have been wondering on who was I representing, or what group on behalf of was I speaking when I argued this case in front of the Michigan Supreme Court, when I write these briefs, when I do this legal work here. The answer is Restore Freedom. As part of that Restore Freedom umbrella, we have the Restore Freedom Initiative Constitutional Amendment Petition, where we are gathering 425,059 signatures to strip away the extra language and garbage, to clarify things so we have if we have governors that want to twist and turn things around anymore, that can't happen in the future. We need your help to get those signatures, but that's part of the group. The other part of that Restore Freedom umbrella is my law firm, Restore Freedom with Catherine Henry, PC. And that's where I'm going to do work, everything that it takes from now on for the rest of my career to focus on ensuring that we have our constitutionally protected God-given liberties. If you'd like to help in any way, you can donate by going to restorefreedomkh.com, because all of the work I've been doing so far in that regard is done by donation. It's done by me volunteering my time. We don't have paid staff here. So with that being said, there's one last question. What about Oakland County? They have supposedly issued an order as of Friday. I want to say it was their health department that issued the order, that they're utilizing public health code. Now, I didn't read the two together, the public health code with their order that require people to wear masks. But I could tell you what, it's the same statute that I have told you guys about and have pulled it up and read it word for word to you many times since April. I've been telling people since April, this is bad news. This is why that 1945 repeal wasn't going to fix anything, because the second that the 1945 repeal, or excuse me, the 1945 law was shot down, she was going to ramp up, and our government agencies across the state were going to ramp up their use of the public health code. This is not about a state of emergency. This is about control. And so, yeah, I do believe that they are following the letter of the law when it comes to the public health code when they are issuing these orders. However, those laws, that's yours, Mike. You got to turn off the volume. Turn it off. The public health code. I guess we have a problem with one of our videos. Are we going? Are we good? Okay, so that part of the public health code, which I want to say it's either in chapter 333 or chapter 325. That part of the public health code is unconstitutional. There are several parts of the public health code that are unconstitutional, and I have shared that in previous videos with people. But now that we have the fight of the masks, now that it is clear, exceedingly clear, 1945 law, a no-go for any governor, 1976 law is a no-go for Gretchen, okay? Now that we have that point finally proven, we need to focus on the mask issue, and I will be ramping up significantly on how to help people understand that even if there is a state law that requires it, which there is now, there's a different state law that they're using. The Constitution does not allow it at all. There's no ands, ifs, or buts about it. So with that being said, I think we covered all of the main points. What?
I would say there's still an issue with, or a question with kids in schools and kids in sports.
So, does your child in school or in sports have to wear a mask? The Constitution says no. In fact, let's assume that there is some sort of lawful order in place that's requiring kids to wear masks in school or in sports. They too would still have the ADA protections, because if they are not medically able to wear a mask while doing that, the school districts and whomever else, they can't stop the children from participating merely because they can't wear a mask. That defies common sense. Besides the fact that these masks, wearing of these masks is not a medically settled fact that wearing a mask is going to stop or even slow the spread of COVID-19. In fact, a lot of the people that have been getting sick over the last couple months, they're wearing the masks and they're getting sick because of the bacteria that they're collecting in and around their mouth and going down into their lungs. So we need to keep all those facts in mind. But regardless of what the facts are, we need to remember the Constitution supersedes all, right? The Constitution supersedes an executive order. The Constitution supersedes a state law. The Constitution supersedes any kind of act from the public health department or order from the public health department. The Constitution supersedes anything that the local school districts are trying to do. So what do you need to do? You need to let your local health department, you need to let your school board know, you need to let your principal and your superintendent know. The Constitution does not allow them to continue this craziness. It's unconstitutional for the governor to do it, and for different reasons or additional reasons, it's also unconstitutional for the legislature to require it, and it's unconstitutional for any person to require these things of us. So contact your state legislator, contact your state rep and your senator, contact your local, your city council or your village board or your township trustees, contact your school board, contact your local health department, and let them know what the Constitution says, because they all took an oath to uphold the U.S. and Michigan constitutions. Every single one of those people I mentioned took the same oath to uphold the U.S. and Michigan constitutions. And if they're not willing to do that, then they're not allowed to be in that office, because that oath meant something. So with that being said, I think we covered all the main topics. I have this board behind me because I was going to put up a few things. I guess I never even did that. Some people are visual. Oh, let's see. Nope. I need the eraser, please. Is it right? Mike, yeah, that one will work. Thank you. Okay, so of course this looks backwards on my camera here to me, but if you're looking for the place where our government officials are required to take that oath, you can find that in Article 6 of our U.S. Constitution. You can also find that in Article 11, Section 1 of our Michigan Constitution. You can also go to Article 1, Section 23 of our Michigan Constitution to find where it talks about our unenumerated rights. And the 9th Amendment of our U.S. Constitution talks about our unenumerated rights that are still guaranteed to be protected. The main thrust of the case, though, in this, as far as how the court determined that her actions under the EPGA or 1945 law, they are declared to be unconstitutional from Article 3, Section 2 of our state constitution. So I at least wanted to remind you of a few of those. If you want any of this information, I talked about all of these in my last couple of briefs to the Michigan Supreme Court. You can find those briefs on Restore Freedom, K as in Catherine, H as in Henry.com. That's restorefreedomkh.com. You can click on the resources tab and then documents, and you'll be able to find my most recent briefs. All of that information and more is in there. And again, I will be very shortly putting out some more information soon to help you share it with others. Again, I realize that there's been hundreds so far of comments on, on the various feeds. I just want to be very clear that I won't honestly even have time to probably look at those today. Hopefully some of my Restore Freedom volunteers might be able to help direct you to answer your questions if there's something that they know of as a way to answer your questions. But I have to be digging into this mask thing even further to stop the insanity. So please join in my efforts, and please reach out to all of those officials that I talked about. And I thank you for your continued partnership to help us restore freedom here in Michigan. Thanks, everyone.